Hello, everyone, and welcome to today's webinar, The Physician Leader, Attorney, Medical Services Professional, a Critical Partnership. Thank you for joining us. I'm Lisa Velasco, Senior Director of Professional Services at the Hardenbergh Group, and I will be the moderator for today's program. Today's webinar is being sponsored by the Hardenbergh Group and MD Review, a Hardenbergh company. Before we begin today's program, I'd like to share a few housekeeping details. All attendees' microphones have been muted for this presentation. To ask the presenters a question, just click on the Q&A icon located at the navigation bar at the bottom of your screen and type your question. As time permits, at the end of the program, I will read the submitted questions and ask our presenters to respond. Your NAMSS-approved CE certificate will be emailed to you within 48 hours directly from Hardenbergh in your thank you for attending follow-up email. Also included in the email will be the slides from today's presentation and a link to a short survey. We hope you will take a few minutes to provide us with some feedback. Now it is my pleasure to introduce today's presenters, Dr. Mark Smith and Erin Muellenberg. Dr. Smith is the Chief Medical Officer of the Hardenbergh Group. He brings over 30 years of clinical practice and hospital management experiences to his work with physicians and hospitals nationwide. He's a clinical professor of surgery in the vascular and endovascular surgery section at the University of California, Irvine. He has expertise in system quality and performance improvement, peer review, OPPE, FPPE, management of deficient performance with practitioners, criteria-based privileging, low volume practitioners, ED call, and external peer review, a focused peer review. Erin Muellenberg is a nationally known author and speaker who brings a strong skill set to her exclusive practice of medical staff law. Having been a director of medical staff services in a large community-based hospital, she is intimately familiar with the daily operations of the medical staff organization and governance processes. Her practice covers advising hospitals, healthcare systems, critical access hospitals, ambulatory surgery centers, and medical groups with the regulatory and compliance and practical requirements for interfacing the medical staff and allied health professional staff with hospital operations. And now I'd like to turn it over to Dr. Smith and Erin Muellenberg.
Thank you, Lisa. Before we get into the learning objectives and the presentation, I thought I'd give you a little background as to how we even came to give this presentation. For me, it really goes back a long ways when I was a first postgraduate year resident in my day, showing I'm old enough, they were called interns. I had a chance to be on the cardiothoracic surgery service and got to take care of a number of patients that were way beyond my ability. And fortunately, they had some excellent intensive care nurses who not only covered me and the patients and helped me get through the night, they even made sure I got enough sleep. And so I realized that you can know all the science in the world, but a lot of medicine really has to do with relationships and team building. And I had a chance about 15 years later, when I became chief of staff, to experience the same result when I was again lost as a new chief of staff and had a medical service professional that really helped me get through. And I quickly learned that teamwork was critically important. And then the second part of this is I've known Erin Muellenberg for a long time, and we have an ongoing dialogue about the interactions between physician leaders, hospital medical staffs, and attorneys. And a lot of this presentation may have grown out of that dialogue that we have ongoing. I can tell you that we haven't reached the end of it. We have a lot more to cover. But with that, I'm going to go through the learning objectives and we'll get started. Hopefully by the end, you'll be able to identify 3 areas of process improvement in the interaction between physician leader, attorney, and medical service professional. Understand when and how to involve an attorney to the physician performance improvement program. Discuss in detail 3 action items to decrease the probability of an unsuccessful fair hearing. Identify 3 areas of process improvement in the interaction between the physician leader, attorney, and MSP. Understand when and how to involve an attorney in the physician performance improvement program. and discuss in detail 3 action items to decrease the probability of an unsuccessful fair hearing. So the way we've set up this presentation, we're going to start with the general relationship and discuss who's involved in this relationship and what their roles and basic responsibilities are. We're then going to, and the bulk of the presentation will be over the areas of concern, a number of issues that arise that are of particular interest that we'll talk our way through, and finally conclude with some recommendations in terms of dealing with all members of the partnership, and wind up with question and answer period. And hopefully we'll get all through that in an unscathed manner. So let's begin with the partnership. Who's involved in this triumvirate? There are physicians, and those physician leaders can be either elected leaders or they may be administrative leaders like CMOs. So there's a couple different flavors in physicians. And then there's attorneys that handle medical staff matters and advise the medical staff in their work. And there's medical service professionals who anchor a lot of the work that's done in this area and become critical in terms of communication and holding the partnership together, so to speak. So that's how we envision the partnership that we're going to talk about today at length. In terms of physicians, just to know that, again, there may be many different flavors. So you may have full-time physician executives. More and more, we're turning towards hiring full-time chief medical officers. We've even expanded that to chief clinical officers, chief information officers, in addition to department chairs, et cetera. So they may be full-time executives who spend all their time in dealing with this kind of administrative detail. More commonly, though, especially at smaller hospitals, we're seeing part-time physician executives. That is, people who do the executive work on a part-time basis and maintain their clinical practice on a part-time basis. A lot of times, this may be an interim position as they go from ending their clinical position and go into a full-time executive position. And finally, most medical staffs have elected medical leaders that are different than the physician executives. These are the representatives of the organized medical staff who fulfill positions such as chief of staff elect, secretary, et cetera, and act in terms of representation of the medical staff in the medical executive committee and communicate directly into the governing board. So physicians can be varied and have many different backgrounds when they come to entering into this partnership. Second portion of this will be the attorney. And I'm going to turn it over to Erin to talk about attorneys and the flavors that they come in.
Thank you, Dr. Smith. And they come in a lot of flavors. And I think that's one of the things that sometimes can get very confusing in this partnership. You know, we have in-house counsel, and you're required to go through and filter any requests for the use of a attorney through in-house counsel who doesn't have any knowledge and doesn't understand why you can't just fire the doctor or why you can't just suspend them, and why we have to go through things. Then, of course, we might have an external counsel for the whole organization. Again, somebody who doesn't specialize in medical staff who has similar concerns will just, take them out, terminate their contract. What do you mean they still have privileges? We should be able to get rid of them. And external counsel for medical staff, and some of you are really fortunate, you have internal counsel with medical staff background. And it's knowing the medical staff background and knowing the medical staff process that really makes a difference in the ability to work with the physicians. And I know many of you have dealt with it, and I've dealt with it, where the role of the CMO and the chief of staff, how we interface with them and who we report to, is truly a challenge. So then we bring the other aspect in, which is the medical staff professional. I'll go to the next slide, Mark. And with that, now we have so many different levels of MSPs. It's wonderful. We have our credentialing specialists, and we go all the way up, to our directors, our executives, and our visions are tomorrow's MSP. Where are we going to be? What are we doing? So our MSP can be a full-time organization employee. They can also be a system director. They can have responsibility for a critical access hospital. They can have a main hospital. They can be over many different areas. They might be payer enrollment exclusively. We don't know, but they're full-time doing that. But then we also have our temporary MSPs who will come in and they bring in their expertise. Every MSP of experience who, goes into a facility, they bring in and they share, which is what we do. They share what the processes are, what the thoughts are, how we can do. But again, we're trying to interface with the elected official, the CMO, the executive, the attorney. And we know that, everybody sort of has their own way of doing things. So sometimes walking and pushing together is a challenge.
So in terms of the general relationship, we break down those areas of concern into communication, time, duties owed, compensation, and a reflection on patient safety. Communication, we're going to go into at length throughout the talk because it becomes critical as to how do we talk with one another and how do we arrange that. Time is most critical, especially on the part of physicians, because it's the one thing that they lack the most of. And so we need to take that into account. Attorneys tend to like time, by the way, because I think they manage to bill according to it, but we can have that debate a little later. The duties owed, a lot depends on what position you take in this. So duties of a chief medical officer may differ from the elected medical staff officer. And so you have to pay attention to that. The attorneys are there to act both in an advisor capacity, but also to assure that we hold our feet to the regulatory and legal fire, so to speak. And the medical service professional really anchors, as I said, this whole process because they bring everyone together and make sure that everyone is carrying out what they need to do. In terms of compensation, by and large, physician executives have some kind of formal pay. A lot of the elected medical officers do this for free or have limited compensation that really isn't true market, fair market value. Compensation of attorneys, again, depends on what kind of relationship that they have. And the medical service professional is working typically for their employees' wages. What I can tell you is that no one gets compensated in a fair manner if you look at the amount of work that this takes. It's just a matter of the way the system works. But at the end of the day, this whole relationship is there to try to ensure patient safety and improve the healthcare that we can deliver to patients. And I think everyone takes that very seriously in engaging in this partnership to date. With that, I'm going to turn it back over because this is way too many words for a non-lawyer to deal with. Erin?
Oh, okay, thank you. And I just want to go back and emphasize what Mark said last, which is patient safety. I mean, I think that is the one thing that when we disagree, when our partnership disagrees, say those words because that's what's going to bring us together. We have constant legal considerations in the medical staff process, and that's the reason that I became a lawyer. I was sitting in, working at my desk, and I'm working with the lawyers, and the lawyers are telling me, well, you can't get rid of this guy. And I'm going, but he's hurting people. Why can't we? This is silly. So it's like, well, I'll show you, I'll go to law school. So I'm not sure, how that turned out, but I'm glad I did because I certainly understand it a lot more now and can help. But when you look at all the legal requirements and stresses and things that hit all of us, it's pretty amazing. And most of the time, our doctors are able to, our executive leaders are able to walk away. The attorney walks away, and it's the MSP that's holding the bag that is there again, as was said, anchoring to make sure we're in compliance with our state statutes, with all the regulations, with case law. New cases come out, the attorneys come out, they talk to us about it, and tell us you can't do that. And it's case law and understanding where that falls in relation to how we work and how meaningful is that, because there may be times that you will violate, or you've heard that a case held something, and you may choose to do something different. That's a risk-benefit analysis that you look at. We've certainly got our conditions of participation, our state operating manual. HCQA is a blessing. You know, HCQA provides immunity to our doctors so that they can do things as long as they do it right. Basically, notice and an opportunity to be heard. That's our due process hearing when we're looking for something. Attorney General opinions you don't hear of too often, but they actually do come into play more than what you think, because we'll ask for, you know, questions about whether or not something is reportable. Yeah, when we fight with the medical board, and we'll get an attorney general opinion as to whether it is or not. Accreditation standards, whatever agency it is, our governing documents to me are the most critical, because those are the laws, the legal considerations that we abide by. Is our medical staff bylaws, our rules and regulations, our policies and procedures. Those really are the governance. You know, you don't think much about provider contracts, but it's something that certainly plays into, again, how our medical staff organization is operating. You know, and our reporting, we hear a lot about that. Hearing rights are critical, goes back to having that immunity in the Healthcare Quality Improvement Act. You know, probably all of us have seen a subpoena come in that's this long, and everybody wants everything. And our first job is to get someone engaged to go back and, you know, really say, here's what we can show and here's what we don't. So we've got this ton of laws and legal considerations that we're dealing with, from EMTALA to privacy to all of these things that, you know, dictate what we do and really influence what we do every day. Go to the next slide. So, you know, your attorney should be your partner. And I think that's exactly what we're saying here, is we want that attorney to know, you know, what's going on in your organization, so that they just don't come in with a cookbook of here's what you do. You could read your own bylaws. We need that partnership. The attorney needs to be able to listen, to see, are there other things that are going on? I can't tell you the number of times that I've sat and I've talked with my partner's medical staff directors, and we're working on a case and we talk it through, and it can be something totally different than what we started with. You know, we need to come up with creative solutions. The advantage that your attorneys have got is that they go to more than one hospital, more than one medical staff. So they can bring the experience in and they can talk about things and create that roadmap for action. You know, we're looking always to mitigate our litigation risk, because the last thing in the world we want is to wind up on the front page of the New York Times as the hospital or the organization who had a doctor or had a problem that, you know, became sensational and all of a sudden is all over. I always say it's going to be a bad day if you get to work and you see the news vans sitting out front. But education is something the attorney should be doing also. And the best thing is that we've got that attorney-client privilege and the work product privilege that can be used, but there are limitations to it. You know, be aware of the fact that there are courts have held that unless you're asking for advice or roping in the attorney, just copying them on an email is not enough to get that privilege. There needs to be something where you're pulling on the attorney's knowledge. So that's
Great. Thanks, Erin. So we've set up the partnership and we've identified who the players are and the various roles and responsibilities. And with that, we want to run into the areas of concern. And I'll just show you which ones we've chosen to walk our way through, and then we'll plunge into it. So we want to go into bylaws, policies, and procedures, credentialing red flags, performance deficiencies, not remediable through normal peer review, abnormal appointments, information from others, disciplinary actions, suspension, fair hearings, NPDB reporting, impaired physician, medical staff documents. If you think that we're going to get through all of this, we know we're realistic to know that we can't touch but a little bit of each, but we at least wanted to give a well-rounded idea of what kinds of areas are important to this particular partnership. So in the areas of bylaws, policies, and procedures, just a word about conflict of interest. It's an important factor to know. I like to think in terms of absolute conflict of interest and relative conflict of interest. An absolute conflict of interest says you shouldn't evaluate yourself, and you shouldn't evaluate your spouse or your brother or some other family member. A relative conflict of interest is anyone who's a partner or competitor could be said to have a conflict because you're going to have some bias that might be natural. Having said that, in most cases, that recognized relative conflict of interest doesn't rise to a level where it stops you from having to participate, or you may be limiting your participation in terms of voting, but in terms of information gathering and getting objective views of point, it's still reasonable to participate. So with that, I'm going to turn it over to Erin, who can give you the legal side of conflict of interest, and we'll dump into indemnification, immunity, and discoverability real quick.
And actually, you pretty much covered it. Just remember that somebody can have a conflict of interest, but that doesn't mean that they have to step aside. Disclosure is what they need to do. They're sitting in a committee. There may be partners with somebody who's under review. They disclose that, and then it's the decision of the committee whether or not that rises far enough that they're going to ask somebody to recuse themselves. So if you don't have a conflict of interest policy, it's something you should have. A lot of organizations are having their docs, sign conflicts of interest every year. So think about that. Indemnification is great. And if you don't have an indemnification clause in your bylaws, take a look, see if you can get one in. And it's really working with the board that you're asking the board in the medical staff bylaws to agree that they will assume the financial liability for your acts, which are being done in accordance with bylaws, policies, and procedures. And they're following the ropes. And so they agree to take on that financial liability as long as it's all being done in good faith and properly under the process. The immunity and discoverability, we talk a lot about confidentiality. And confidentiality and discoverability vary throughout our states. We've seen some states where, things are just wide open, other states where they aren't. We all know about PSOs. They're able to keep some things, but they're limited on what we do. So a lot of this is going to be state-wise as far as discoverability, but the immunity, we still turn back to the Healthcare Quality Improvement Act. And that's what's going to give us immunity from damages when we're doing things in accordance with following the law as it goes. Mark, I think the next one is yours.
Yeah, so I'll just reemphasize that immunity comes at a federal level and applies to everyone across the board as long as you follow the HCQA precepts. Discoverability, which has to do with looking at documents such as minutes, et cetera, is typically at a statewide level. That discoverability is different in the federal courts, and most actions take place in the state. And so the state laws on discoverability are what action. So you have to know if you're in a state that allows for discoverability or not. It's important.
And if you're really lucky, your state has got immunity too. So
yeah,
it varies.
Yeah, then you're doubly protected, essentially. Right. All right, so credentialing red flags. We all kind of know that there's certain things that just, say this is a problem. This isn't the person that we're going to smoothly get through the situation, but rather are things that we need to look at. And the old adage in credentialing is you never credential someone with a red flag. You want to resolve the red flag before you get to the end of credentialing and making a final recommendation. But the question arises is at what level are credentialing red flags able to be handled all sort of on the ground with the MSPs and with the physicians? And at what point do we need to get attorneys involved? When should they become aware? And so I'll let Erin weigh in on when the attorney, from the attorney perspective, when does the attorney need to be apprised of what's going on?
From my perspective, I think we work best together if we know as soon as you find the red flag. So we can talk through at that point in time and come up with a way to try and deal with it. If we're getting a new applicant, they have some red flags, maybe we discuss that we do a laundry list letter. We look at, do they meet the qualifications? We look at a variety of things. So, the bottom line is my recommendation is always to bring your counsel in as early as you can, just to get their advice and see which way to go so you can get that roadmap.
Yeah, I mean, there are going to be some credentialing red flags that are sort of routine and can get resolved quickly. And so I'm not sure you always have to let the attorney know of every single one, especially when it's routine situations. But I would definitely agree that if you get one that isn't going away or isn't getting resolved quickly, that's a good time to get the entire team on board, so to speak.
So we don't want we don't want Dr. Dunchapline at our hospitals. We're going to flag him.
Exactly. Well, we can talk about that particular failure of process. So we thought we'd go under performance deficiencies, which is a particular area that is problematic for people. We have normal peer review, and most performance deficiencies are remediable through normal peer review. Just the fact that they're being looked at, that education can take place, et cetera, usually corrects most of these. So we're really focusing in this case as to what happens when our basic processes don't work and we have to carry on going forward. So we have FPPE, focused evaluation for cause. This is not the FPP of someone applying new to the organization or having a new privilege where we're just doing FPPE because we don't have any firsthand knowledge per se, but this is rather the type of FPP where we've identified a potential cause and we're trying to do further investigation as to whether or not this is real and what the problem may be. If it gets severe enough, then there's a thing called investigation, which is where it's at a level, typically at the MEC level, where they're very concerned and they're going to do a final evaluation to make a recommendation to the MEC about whether or not any kind of formal corrective action should take place. A lot of times in this day and age, there'll be coordination with the HR department. It used to be not, because most physicians were independent practitioners, but now so many have become employees of hospitals or hospital systems that a lot of times they have a dual role with the HR, and so we need to think about that. There's also implications for reporting to the National Practitioner Data Bank and to state medical boards that we need to be aware of. And further, we need to be aware that external reviews are a very important tool before you go to any final action, because you never want to be in the position of taking a final severe stance on a practitioner without getting an outside opinion that just should corroborate what you're looking for, but it gives you a much sounder basis for taking an action. So using external reviews as a strategic tool, I believe, is very important. And all these areas, the partnership needs to weigh in on and be a part of, because we're now looking at situations that are rising above what the normal practice is, and you can lead to corrective action, fair hearings, et cetera. So I think you really want to have everyone on board for where we can go with these items. Erin, you have any thoughts on that beyond that?
Well, I do. I mean, whenever we're getting into an FPPE for cause, where it looks like it could be a precursor to disciplinary action, that's what's going to rise and bring in reporting implications. So there are things that your attorney can help you navigate. And really coming up with some solutions that are creative that you can work through to get what you want, and still, try to aim for remediation. So that's my only thing, is precursor to disciplinary action, then we've got serious implications.
Yeah, just to make sure everyone's aware, and we'll talk about the National Practitioner Data Bank a little later, but they changed. It used to be that until it rose to a level of investigation, and if someone resigned while under investigation, it became reportable, but short of that, it wasn't. So a lot of times people would negotiate that before it went into investigation, they would go ahead and resign so that it wouldn't be reportable. Well, the National Practitioner Data Bank changed that. And so now it's anything that rises above normal baseline peer review is really a reportable event should someone resign before there's any kind of finish put to the evaluation process. So that's an important aspect to keep in mind. Abnormal appointments. Well, this is becoming an area that's of real interest because, as you may know, the Joint Commission just changed their ruling from the 2 years to the ability for organizations to go every 3 years. And that's going to be a decision that each organization is going to have to decide whether that makes sense to them or not. It should be a no-brainer. Why would you want to do something every 2 years when you could do it every 3 years? It's less work, and that is true. But it also means that you may not be taking a careful look at each individual on an often enough basis. I know we're supposed to have OPPE processes that are always looking at competency and checking on it, but I would say that most organizations in the country don't really have robust enough OPPE. And so we still fall back on the reappointment process as a time when we can reevaluate all the information that's there. And if we extend that from 2 years to 3 years, are we allowing certain people to fall through the cracks for a longer period of time? So it's not a black and white kind of decision to go from 2 to 3 years at this time. Ultimately, you'll have that opportunity, but it's out there. Erin, you have any thoughts on 2 to 3?
I do. And I think it's something that we all need to be thinking about, because how often have we given somebody a 6-month appointment? And that's a tool in our toolkit, especially from the legal standpoint, that we can say we can give a limited appointment and we don't go from there. But if we move from appointments now and we instead talk about reappraisals, we start really that ongoing process, we can still look at ways to do things and put those limitations on. We certainly are going to be more creative as we go forward. But it's just, as Dr. Smith said, it is one more thing that we need to think about as to how do we deal with those issues where we would usually give a limited reappointment, and how we're going to do it.
Yeah, this is one of the most dynamic areas right now, and I don't think we have clear-cut answers for it. But I know a lot of people are starting to talk about it, and so I think more active options will come about. This is kind of, to me, somewhat the law of unintended consequences coming about. So you have to be careful when you see these changes made. Information from others. So we get information. The best information that we can have on our practitioner comes from our own information that we have internally, because we can account for how we got that information. We know when we measure their performance based on actual data that we have from care being delivered in our organization. We understand that. But in a lot of cases, we don't always have that information. You may have practitioners who are low volume practitioners, and they mostly work at other organizations, and they only show up to cover someone once a year. Or you may have newer people, or you may have people that work in multiple places, and we get notice of actions that are being taken elsewhere. And so we don't have necessarily all the information per se about that, but we have the report sitting, say a disciplinary action at another hospital or actions by the medical board. And finally, there's peer references are always a problem, because you never know how good a peer reference is. Oftentimes, peer references are chosen by the practitioner, which, someone used to say, if someone gets their own peer references and they don't give them superior, you ought to just forget about that person based on stupidity, because you ought to be able to go find someone that's going to say you're great. But how we get our peer references, more and more what we're seeing is organizations getting peer references of their choice rather than the practitioner's choice, so that we seek opinions from people who have actually seen the practitioner work and can account for their competency. And finally, just a word about malpractice judgments. No knock against lawyers, but the rate at which malpractice cases come is different from state to state and from area to area. And so what may be in rural areas where they don't have very many of these actions, one malpractice suit would seem like a lot. Would be just humdrum that every doctor has a malpractice judgment in states like California, where we have lots of lawyers to bring lots of actions. Also, the type of practitioner you are. If you're in a high-risk specialty like spine surgery or neurosurgery, you can almost expect that you're going to see a lot more malpractice cases. So you have to evaluate not just the number of malpractice cases and judgments, but what were the actual facts of those cases that led up to it, and whether the care was truly problematic, because that's what you're interested in. You're not really interested in what kind of money was paid in a judgment. What you're interested in was the medical care that was delivered defective. Therefore, we have a problem that we need to resolve before we can allow that practitioner to continue to treat our patients. Erin, I know you have something to say on that.
On the malpractice judgments,
No.
Again, it's something that we need to look at. And there are like OB spinal surgery, like Dr. Smith said, it's going to be a high level, but no, it's something that has to be looked at. And when we talk about peer references, the only thing I'll say is we always know that the reference that was sent over on Dr. Dunch said he was great moral character and gets along well with others. Didn't say a word about his competency. So got to read him carefully.
Makes you worried about what we're teaching about morality out there in the world, I guess. I don't know.
Well, it does, but I do think it also emphasizes the need for all of us in this partnership to examine these things. So it shouldn't rest on just one set of eyes. It's always on several sets of eyes that are looking at things.
Yeah, and I think that's a good general point to say that one benefit of this partnership is that it's a team and that we have backups, so that not everything falls to one person. And the chances of things falling through the crack when we have all parts of the partnership participating in the manner that they're supposed to becomes quite small. Versus if things get siloed and handled separately, then there's a much greater chance of a problem. So there really is, I think, great benefit to having this teamwork go into effect. Disciplinary actions. I'm going to throw disciplinary actions to Erin because that's when she gets involved a lot. So
I do. And, it's always at the point where there's already been an investigation letter sent. The die has been cast. We're going down the disciplinary road. And there's nothing more disappointing than if I come in and I say to you, well, show me all your documentation, we're getting ready to go to hearing, or you've called me at that point. And now we go through and we say, well, there isn't any documentation. Well, I can live with no documentation. Tell me who's going to testify to this in the hearing. Oh, what do you mean that who was going to testify doesn't work here anymore? Now will they come and cooperate? And we've had cases just absolutely go south when we've got a clinical performance concern and there's a problem, or there's been a suspension, and this has happened too, and we send the cases out for an external review, and the external review says they're within the standard of care, which, we're looking for objective review. So now we just rework things. But we always want to take it and follow the steps. And if there's one thing that I can ever beg of anybody, because I do it every day now, still as an attorney, is create chronology. When we've got an individual who's a problem, go back, as far back as is reasonable, oftentimes to the beginning, start a chronology, because when you're looking at those files, you're going to see stuff that wasn't seen before. It's going to come into play into context. We're going to put, behavior and performance together. And I think I asked you this yesterday, Dr. Smith, but is behavior totally separate from clinical performance?
Yeah, so if you look at the data, the suggestion is that if you have a behavior issue, if you look carefully, you often see that there's clinical performance issues as well, kind of tied to it, because quite frankly, the care that's delivered can be impacted purely on behavior and yet result in poor clinical performance. I'd also say that I think the chronology point that Erin made is really important when it comes to behavior, even more than clinical performance, because clinical performance oftentimes degrades in a fairly short period of time. And so you need to have up-to-date information on clinical performance. Behavior, on the other hand, tends to be an indication over time of the general approach to things. And so what we find is that behavior tends to fly under the radar, so to speak, because there's lots of elements that can show up if you've documented them well, but none rise as a single issue to a point where any action is taken. But if you get them all together, you can get the real picture of the behavior. Whereas clinical performance, we're usually measuring in the last 2 to 5 years. Once you go back more than 5 years, you can't claim that good clinical performance from 5 years ago means anything other than maybe as a backstop to see a degenerative performance happening, that, gee, they're not doing as well as they were in the past. But the point is that you can't depend on data from greater than 5 years ago clinically, but behavior you can. So you really want to make sure you maintain those records.
Yeah.
So this was an illustrative case of that. And
All
Erin,
right.
you were going to
Sure.
ask a question on it.
So the history of the angry outburst in the OR. So no, I was not going to ask a question on that one specifically, but just going back on the prior slide, we had the picture of the impaired practitioner, and what will make a difference in being able to deal with that type of a situation is that chronology and that history of other concerns and complaints. So it just comes back to that. So
Yeah, I think the other
Go ahead.
problem with behavior is a lot of bad behavior was accepted. It
Oh, yeah.
wasn't condoned necessarily, but it was accepted and allowed to happen. And if it was, it kind of sent the message subconsciously that it was okay to do this type of stuff. Then when you start to enforce behavior codes the way we are doing in today's world, all of a sudden you find that people are getting upset because, well, I used to be able to do this. Why can't I do it now? And they used to have a lot of excuses that were given because inevitably it's always the big practitioner that does this, that supplies a lot of economic benefit to the organization. And again, you have to go back to that principle of what's best for patient care, because that's going to be your guide to how you make good decisions.
And that's a real challenge. Did you want to do that other case study, or are we okay on that?
I think we're okay on that. I think
Okay.
we got out our points on that. So as we're going through the process, we get to suspensions, which is the taking away of someone's privileges and setting up the possibility of fair hearings. And we have a number of different kinds of suspensions. A summary suspension is one that's done on an immediate basis when you think that there's a real danger of danger to a patient care that's immediate, and you have to take action right away. Precautionary suspension is one that's done in anticipation that we don't know enough, but if we let it go through and care continue, that it could be problematic, and we tend to have specified periods of time for precautionary to collect some more information.
And can I comment on that one right there if I
Yeah.
can? You need to be extremely cautious with a precautionary suspension because the data bank and many of the states will look at a precautionary and call it a summary and see that a precautionary is nothing more than a way to avoid reporting. So please be sure this is one area where you absolutely have got to consult counsel on it. Look at what the data bank is, but we've seen cases where a precautionary suspension has been in place and there's not been a report made. And then what occurs is that the individual or the organization is in trouble with the state medical board or with the data bank because there wasn't a report made.
Yeah, what I've seen with precautionary is that you have to have really short time frames to it, because you don't want to extend this for any period of time. Just kind of gives you a quick break to try to gather information, that as opposed to summary where there's clear indication that there's immediate danger to patient care, and so you have to stop their ability to deliver care right away. But I would acknowledge that precautionary is a gray area that can be problematic. Recognize that it can be for clinical competence, for conduct, or both. And as we said, we think the most common is that we see both when it's involved with conduct. And finally, there's administrative suspensions. These are for things that aren't necessarily competence or conduct, but we've already set in our rules to say that you're not able to deliver your exercise your privileges if you don't have malpractice insurance, or if you lose your license, or whatever the administrative reason is. So there isn't a specific competency case that's called or a conduct, but rather you'd lose the sort of the administrative ability to exercise your privileges.
Yeah.
And that's kind of straightforward usually.
And if I can comment just a little bit further, suspensions are probably the quickest way you get into court with a physician, because once they're privileges, you need to understand that a doctor's right to practice is a fundamental property interest. And when we take that away without due process, which is what we're talking about when we do an immediate suspension, that individual can go into court at that point and question whether or not there was a basis to do that. So it comes back again to suspensions are the one area where I think you really need to get your counsel involved, make sure that you have followed your bylaws and that you're doing everything as should be done. Now, that does not apply to administrative suspensions because those are automatic. But if we're talking about a summary or a precautionary that's based on competence or conduct, and behavior still goes and it's tied there, professional conduct, then it's something that needs to be reviewed and discussed very thoroughly and really examined to make a determination whether or not that suspension stays in place.
Erin, can you talk quickly about, you talked about going to court, and there's two pathways. There's the court pathway, and then there's the fair hearing process in the medical staff bylaws. Can they go forward simultaneously, or will the court suspend until the fair hearing process is completed? What's the story on?
Yeah, so the answer is it depends. When somebody gets a suspension, they will try to run to court and say this was unjustified. The organization's response is to say, wait a second, they have an administrative remedy. That is the fair hearing process that's provided in the bylaws, in the organizational documents. The courts will generally say, go back and finish your administrative remedies first. We call it exhausting the administrative remedies. Then if you don't like how it came out and you still want to go to court, fine, come back again. But it's, what it is that we do have that ability, or we can see where the suspension occurs, they'll try to get their rights to practice back before a fair hearing. And we want to keep them pushed back so that they are in that fair hearing and that they have all that due process where there's the full examination of the facts that led to the suspension or the recommended termination.
Yeah, so that was the point, is there is a fair process hearing, a fair process to go through. So you don't always necessarily get to go right to court. That's a fear of a lot of physician leaders, is that they're going to wind up in court right away. So
they do, and that's where we cover it and kick them back.
Yeah. So this was a short just case summary on suspension, and it's someone who seemed to be under possible substance abuse. That's an immediate danger to patient care, and so you really need to consider a suspension in that case. But for time constraints, I think we're going to push on. Fair hearings. Anything more on the fair hearing process that we've already touched on?
No, the fair hearing process is there. Don't be afraid of it. That's the biggest thing that I have to say. Is we have fair hearings in our bylaws for a purpose. We give somebody notice of what they did wrong. We give them an opportunity to be heard. And there are ways that we conduct these efficiently and without, a lot of problems so that they can be done. Just don't be afraid of them.
Yeah, well, it may be good advice to not be afraid of them. I try to avoid them because they are time consuming and expensive. So if we can do anything to get away from fair hearings and you get some kind of resolution that's reasonable. But I agree, there are times when you just have to go ahead with it and know that it's there. I think we've talked about NPDB reporting pretty much, so I don't think we need to spend much time on that. The impaired physician, this is another pathway because quite frankly, our usual remedies in the medical staff process are somewhat punitive. It's going to go towards taking away privileges and having fair hearings. And an impaired physician is one that may be able to be healed. And so what we found is using a pathway through a well-being committee and making a decision about whether or not they can be diverted. Obviously, you can't have them exposed to patient care if they're in an active impaired state, but there may be a non-punitive way of trying to deal with this. And physicians actually have one of the better records of getting through impairments and getting back to being functional again. So I think it's important to be aware that we have these two pathways and to make good use of the well-being committee. Oftentimes, they're also used in terms of evaluating conduct problems as well, to make sure that there's no underlying physical or mental process that's going on leading to poor conduct. They have a lot of uses, and I'm a big proponent of a robust well-being committee. And finally, medical staff documents. Everyone kind of laughs about these and kind of views it as a pain in the neck, but the reality is this is what you get held to. And if you fail to meet your own requirements, you're going to get hoisted on your own petard, essentially. So you need to be aware. And one of the reasons we recommend going over bylaws on some regular basis is the fact that they get outdated quickly. And you may be held to things that just don't make sense in today's age. So just a plug for looking at your bylaws on a regular basis, know what they are, and make sure that they're up to date and make sense.
And I would just add, be sure and bring your attorney into it, and an experienced MSP can look at bylaws, see where there are problems, where there are issues. You know, an attorney can help you with fair hearing plan and corrective action, and that's a critical part for you.
Yep. So that's kind of our quick trip through the concerns. Our last couple minutes, we just have some pointers on how to deal with the various parts of the team, so to speak, the partnership. So, Erin, how do we work with legal? Tell us how to work with you.
Legal is really all about communication, and it's having that relationship, just like we have with our other partners. Is, you know, can we pick up the phone, call them and say, hey, I may have something brewing. What do you think? Or I'm looking at the bylaws and the rules, and it looks like there's a conflict between these two. How do we handle it? You know, and just having those documents that are organized. We talked about the chronology earlier. It's there. Governing documents are your bylaws, your rules, your regulations, your policies. And certainly you know all about that. And you just want to make sure that they're fresh. I'm working right now on a fair hearing plan that was last updated in 1998. So you can imagine what my challenges are there. And we want to be sure that we're looking at them all the time, because it makes the difference for how the whole partnership works. Yeah, and I think clearly understanding of the stakeholders, you know, just telling, if you can tell your legal attorneys who we're dealing with, it'll make all the difference. So let's go back to physicians and.
Yeah. So physicians, I would say, just remember that time is the most precious commodity for physicians, and you need to be aware of it. The really good MSPs know that really well. And so they tend to handle and manage that process, and know that there's scheduled times and unscheduled times, and they need to take advantage of both. Also understand what their needs are and what their knowledge base is, because not everyone is equal in this. You may have a very experienced chief medical officer who's been through the wars and has good understanding. You may have a newly elected chief of staff, as I was a number of years ago, and you know, you're just out in the woods on your own on that one. So you need to give them a lot more support. Finally, there needs to be some kind of organizational memory, and that's tough with elected medical staff leaders who typically only have a 2-year time frame. One of the reasons why chief medical officers and administrative positions are rising is because they tend to last longer and be in that create organizational memory that helps improve that. And finally, recognize that there's a number of different agendas that can be in place. And to the extent you can align the incentives that'll work better in terms of dealing with the physicians. And then finally, working with MSPs, and I think we can all kind of chime in on this one, but the first point I would make is MSPs are professionals, and they need to be treated with professional respect, in the same way that we deal with the attorneys and with the physicians. And I think if we start with that and then get them to know that they understand the communication role and the role they play as the anchor in a lot of these. And finally, the issue that a lot of MSPs have, which is of dual loyalty, that they are hired and employees of the organization and supposedly need to report to the administration, but at the same time, the doctors view the MSP as their person. And so in a way, they almost have a dual loyalty going forward that sometimes can put them in uncomfortable positions. The really good experienced MSPs know how to handle that really well, and therefore are of great value to the organization because they have the ear and the trust of the physicians. Biggest thing that they need to be able to say is no. That's a really tough word for a lot of MSPs because MSPs are used to saying, I can get it done. Essentially, they cross the line sometimes to enablers. So they just have to be careful on that one. And know that they're communication center and experts on governance to really help the physicians in their work.
And if I can just go back just a second on that to the professional respect, I think the important thing that we've seen develop over the years with the partnership is not just professional respect, but that when it comes to the medical staff organization, we are peers with the attorneys, with the physicians. So we're peers in that knowledge. Don't be afraid to speak up. You know, bylaws, rules, regulations, the policies better, and it's bringing it to the table. I've still seen some people that are not willing to step up, but be there and demand that respect. You're entitled to it.
So, if nothing else, Erin has this last message for you.
So the last message is preparation makes a difference. I mean, it
That's
really
right.
does.
Yeah.
It does make a difference.
So Lisa, I think we turn it back to you.
Yes, thank you so much. Dr. Smith and Erin, you've provided us with some valuable information today, and it's so timely for the future of tomorrow's MSPs, especially with the challenges that we're facing on a day-to-day basis in our operations. And we have a lot of questions for you today. We have a few minutes left. I know we're short on time, but if you'd like, I'll go ahead and ask the first question. So the first question is, what can you do as an MSP to actually make hospitals accountable for the negative reports and disciplinary complaints they receive on physicians, but do nothing about it?
Yeah, I'll take a shot. Yeah, no, I'll take a shot at that because that goes back to not sharing information. And I think that is something that we all disagree with when all of a sudden we get burdened with somebody. And it's got to come back to your organizational culture. Part of what you're building with your MECs is, are we willing to share? We're seeing more and more organizations that are now willing to share and say, factually, you know, we're talking about facts. This individual had behavior problems, was placed on FPPE. Hopefully you can go on and say during that course of time, he or she was absolutely great and there have been no further problems. But it's that transparency and that sharing that needs to be there. Dr. Smith?
Yeah, well, I would say that if the hospital is not reporting, to me, that would be a failure of the medical staff and the elected leadership of the medical staff for not taking proper actions. I don't know of any hospital that steps in and prevents the medical staff from taking appropriate actions. So it's usually a medical staff itself that isn't holding itself accountable to the world. And I think the MSP would need to have some talks. That's really, again, another place where a CMO has come into good use, because the CMO can be that physician filter that crosses the line and helps the MSP in that type situation. But it's not going to be acceptable to say that it's okay not to just ignore the bad outcomes that are there. You need to do something. So.
Sure.
Yeah, and I do think we've seen an increase also in agencies and the data bank, and also the state medical boards are coming down when they learn of things that haven't been reported that should have been reported.
Yeah.
So you do with the data bank, you place yourself at risk of losing your immunity, and your medical boards, various fines and penalties.
It's kind of an argument for having the robust partnership of all the groups, because an MSP shouldn't feel like they're out on a limb alone in that situation. So,
Sure. And just as an MSP, I always look at it as, how are we going to defend it in court? And what if we're in the public eye? You know, some states have that sunshine law. And then also asking that question, would you want that practitioner to operate on your family member? And just asking those questions and bringing that to the forefront sometimes makes them think that, you know, it is time to do something about it. And always go to the medical staff, because, you know, that's the decision body along with the board. Have another question here. We're an academic facility. We have a peer review committee and we have a CME committee. Do you consider an M&M, Morbidity and Mortality Committee, to be a peer review committee, an educational committee, or both? And how does your organization handle it?
well, I'll weigh in on that, because that depends on the organization. So I work at an academic institution where our M&M, at least in the Department of Surgery, is run concurrently with peer review. And so we present cases, but peer review and M&M differ in the sense that peer review is the rating of care and the compiling of information about the competence, whereas M&M is an educational value discussion, an interesting case discussion, or a discussion about issues that the clinical care raised that everyone can learn from. In academic institutions, because we actively are teaching in a hierarchical fashion, all the way from the attendings down to third-year medical students, that seems to work out better. In community hospitals that aren't so academically oriented, it's much better usually to separate M&M and peer review, because it's very difficult to do those together. And then in terms of CME, that's the educational value that may be applied to get credit. So you'll have to decide if you're truly giving educational value, then you could apply for CME. But if it's purely a peer review process of rating case care delivered by practitioners, I don't know that that can really be justified solely on the basis of education or CME.
No, and I agree with you completely on that. And if it's medical education, there's questions about protections on it. But if the goal of all peer review is education or remediation, then, you know, peer review can send things to CME committee to work on and educate on, without it being about an individual.
Yep, exactly.
Thank you. I have a two-part question. The first part is, do you recommend having an information sharing agreement for employed providers between HR and the medical staff office?
That is a legal question. So my answer is not necessarily. And the reason for that is because there is a difference in the process. The process for medical staff is, if you're going to discipline somebody, then they get a fair procedure or due process hearing under your medical staff bylaws. HR works totally different. And what we don't want is, we don't want the sharing of information where the peer review body has given the information to HR then turns around that and uses that for an employment decision. Yeah. Now, there are some circumstances where, again, we got to look at the medical staff privileges separately. Some laws where they can lose their employment, they don't lose, some states where they lose their employment, but they don't lose their privileges.
Yeah. Yeah, I would say that HR typically is not a peer review protected process. So as soon as you gave peer review information to an HR system, you'd lose the protections that peer review has. And so I'd be very careful about that, because you may be opening Pandora's box in terms of exposing your peer review information.
Okay. And when it comes to some of the credentialing elements, would you suggest to have a sharing agreement to share those elements like DEA, license, malpractice, things that can be shared, that and including maybe public information? Would you recommend a sharing agreement for that aspect of employed and private practitioners on the medical staff?
Either that with a sharing agreement, or also if you're using a CVO and it's going for those purposes, it's a matter of contract. So whatever, you want a paper trail that limits and explains who gets what.
Okay. The other part of the question, and I think you may have answered some of it, is do you feel that it is quicker and less resource intensive to handle severe quality issue concerns with employed practitioners through the employment termination process versus going through the medical staff process of hearings and so forth?
Can I just comment on that? That is a trend that we see most often, where people just want to deal with it quickly and have it done. Some of you may recall there was a case probably about a dozen years ago out of Texas called Polliner, and Dr. Polliner won an award of $369 million because, again, it was a contract process. It was not handled through the due process where there are immunities. There was a PA up in Northern California that got $170 million, I believe, because, again, she was dealt with on an employment basis. The advantage of doing the hearings is the immunity. That's what the Healthcare Quality Improvement Act was designed for, was so that we could give somebody that fair process where they have the right to come in and say why they shouldn't be disciplined, present their evidence, we rebut it, or however it works, and then there's a decision, a fair decision. Once that notice and hearing has been given, then there is immunity under the Healthcare Quality Improvement Act and some state laws. So I really, I know you're in a position sometimes where you're going to be asked about just doing it from an employment standpoint. I think that's the answer that you have to give. Sure you can, but there's no immunity.
The other problem is the HR process shortchanges the peer review evaluation. And so you may not have the answer. You may have identified a potential problem, but if they went ahead and terminated before you went through your entire evaluation process, you're kind of left with an unknown. In fact, a number of institutions will carry out and complete the peer review evaluation regardless. And the problem then comes is if at the end of the peer review process, you decide that it wasn't justified to take any actions, but they've already taken an HR action, you may be at loggerheads with the HR process. So most people will not carry through the peer process, but then that just leaves you hanging, so to speak, on whether or not that was really a problem. So it's a real problem issue, I think.
Perfect. I believe we have time for one more question. There's a lot of questions, but we have time for one more. Thank you all for staying with us. Can you deny a physician an application? And if you do, what kind of legal situation could that put your organization in?
You absolutely have the right to deny an application, but it's going to be on what the basis is. If they don't qualify, then is it really a denial, or we're just saying they're not qualified? If it's somebody who's had prior disciplinary problems, that has prior actions, and they don't meet your standards, you choose to deny them, then yes, and according to your organizational documents, you should be required to give them a hearing. Again, that fair hearing where they have the due process rights, notice, an opportunity to be heard, to rebut it, to say that they're qualified, and then you've got the immunities from damages. Doesn't stop a later lawsuit, but you've got immunities from damages.
Part of the not qualifying, though, may be that they qualify for membership, but it's a closed department by contract. In other words, a lot of places will say all their emergency room doctors work under a contract and are supplied through that contract. If an independent ER doctor then tries to apply to the medical staff, they may be denied the ability to fill out an application on that basis. Not that he's unqualified to be an ED doctor,
right,
but they don't have the ability to give that application out right now because he would need to be part of that contracting group. So there's a lot of different reasons why you may not have someone complete an application.
Okay, I'm going to throw one more question, maybe two. There's so many great questions here.
Lisa, I'm sorry. If we have questions that we can't get to, will we maintain that so that we can get answers out to people on them?
Yes, we can certainly do that.
That'd be great.
Yep. So I'll go ahead and we have one more. And if you hear of a provider that's been accused of a serious crime, would you put them on a precautionary suspension? This is assuming that the medical board has not suspended the license.
Okay, so I'm going to answer it with one. I don't use precautionary suspensions because a suspension is a suspension, and I think you get in trouble if you do that. But if we've just heard about it, it's hearsay. Are we going to investigate it? Absolutely, we're going to investigate it. And that comes up. Somebody might have a DUI. They might have injured someone in an accident. It occurs. So we do the investigation, then make the determination of whether or not that individual is going to be an imminent danger to others, such that we can't allow them to take care of patients. If that's the case, then you impose a suspension.
Yeah, I think you're on sort of unsettled ground if it's just been an accusation, but not proven or carried through to the end of the legal process. So I think you have to do the assessment that Erin talked about, which is based on what we can learn and know, is this person a danger to patient care at the present time? It's easier after say they've been convicted, because oftentimes we have rules that say you can't have a felony conviction and be a member of our medical staff. That makes it almost an administrative reason why we can't keep someone on.
Yeah, and I'm glad you brought that up, Mark, because I want to be clear that I don't intend that they have to go all the way through the legal process and be convicted. If there is enough that somebody's been charged, and then under those circumstances, we're able to get the information from the DA or from the police department, then yes, we have taken and placed suspensions at that point in time. Because again, the burden is then on them to prove that we're wrong. We have to protect patients, so we put patients first.
Right. It's what information you can get at the time.
Right.
Okay. And there was a second part of that question. Is a precautionary suspension reportable if an organization does utilize precautionary suspensions?
I think you stand challenged with that if that suspension goes beyond the reporting time for either your state medical board or the data bank. So if you go over 31 days, you called it a precautionary suspension, I think any one of those organizations is going to look at it and say it's a suspension. I think you also run risk if you're not giving hearing rights on a precautionary suspension, because again, you're depriving somebody of their fundamental due process rights or fundamental property right to practice without giving them a due process hearing. So there's a lot of risk in using a precautionary suspension, much lower risk to just put your information together, call it a summary suspension, and go with it. But that's something you've got to discuss with your organization and your council. So.
Yeah. And know that the reporting timeframes are different for states than they are necessarily for the federal government. So be aware of both.
Okay. Dr. Smith and Erin, thank you for sharing your expertise with us today. And as a reminder to our participants, you will be receiving the email with the slide deck from today's presentation, along with the CE certificate and the survey within 48 hours. And we want to thank you again for joining us today. And Hardenbergh looks forward to providing you with future thought leadership webinars. Wishing you all a great rest of your day. Thank you so much.
Thank you.